It's another cruise video that I put together for you while I'm off on vacation. So, in this one, somebody wants to know about when open ended questions and leading questions are allowed in court. I'm going to tell you. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. One of the things that frequently frustrates new watchers of courts online is the objection that says leading. In essence, the lawyer is objecting to the nature of the question because the question actually suggests the answer.
Once they arrived, shortly thereafter, you learned that Mr. Hines claimed that he had been jumped over at a party earlier that night at 5 Lazy Brook Road, right?
Yes, I heard.
Now, that's a leading question. How do we know that it's a leading question? Because it suggests the answer. In fact, it pretty much mandates the answer. He is telling him what it was that he observed or witnessed or saw or said. And whenever you tell a witness what they saw or observed or said or anything like that, that is considered to be a leading question because it suggests the answer. And the reason it's so powerful on cross examination is that it lets the lawyer tell the story instead of the witness telling the story. The witness is essentially being used as a marionette to tell the story the lawyer wants to tell. And it's a very powerful tool. That is a leading question, and we now have to contrast that with an open ended question. Let's take a look at one of those.
So when you heard this punch happen, what, if anything, did you observe next?
So I instantly saw Tyler Rich and Da Silva wrestling. I guess that they were on the ground together. It looked like Da Silva was like on his knees, a little bit over Tyler Rich with like his shirt pulled up. But I know Tyler had some type of like grip on his like around his head or something. It looked, it was just really them two at that moment. But I had gotten closer to them with a couple other individuals, kind of just seeing what was going on. We weren't ready to break it up yet, but more so just observing. Like we knew Tyler could handle something on his own, so we were just not getting involved yet.
Now, what you saw there was an open ended question. And did you notice the difference in the delivery between the leading question, where essentially the answer came in as yes, and the open ended question, which allowed the witness to narrate a series of events that occurred while he was observing? And finally, when he catches a breath, the lawyer asks him another question. But in that particular case, the Connecticut versus Valley case, there were a lot of times when the prosecutor did not restrict himself to open ended questions. For example,
But there were probably a couple words that were exchanged from what I can remember. Yeah.
Was it argumentative?
Yes.
And
was that question objectionable? Certainly. He could have objected to that. The defense could have objected to the question because it was, in fact, leading. And of course, at that point, the prosecutor would have said, well, how would you characterize the tone of that discussion or whatever? And he would have said, yeah, they were arguing with one another, or it was argumentative. Whatever it was that he wanted the guy to say, he would have said based on the first question. But the record would then be clear that it was an open ended question instead of a leading question. The main reason why attorneys don't object to leading questions like that is because it annoys the jury. You're basically elevating form over substance, because the answer to that question, was it argumentative, is not going to be dispositive of the case. It's not something that the whole case hinges upon. And so for that reason, you don't always object to things that are in some ways a leading question, or could be characterized as a leading question, just like that one was. And so it makes sense to be judicious with what lawyers object to, because again, if you're sitting in a jury box and you've been there for 3 hours and you've listened to the lawyer drone on, you've listened to some of the witnesses drone on, now this guy can hold the person's attention pretty well because he's narrating something that's very clear to him and that the jury understands it was an emotional event for him. But there are a lot of times when it just is plotting, particularly where you're going through where items were found in a crime scene or what a criminalist did to get ready to take the stuff back to the lab. All of those things can be pretty boring. So in that situation, you want to avoid annoying the jury any further. And particularly with experts where the person is laying a foundation, didn't you go to Harvard? Yes. Didn't you go to Yale? Yes. Didn't you, things like that. You don't want to, if you're a lawyer and you value the jury's time, you don't want to object to every single thing. But for the most part, the only time you're really supposed to be able to ask leading questions is when you're cross-examining a witness. Now, courts sometimes make an allowance for a hostile witness. And if you call the opposing party and they're not playing straight with you and answering your questions, sometimes the judge will allow you to treat them as hostile. And in that situation, you get to ask leading questions. And you do that in order to get the witness to answer the questions truthfully and without filibustering. This can sometimes be very, very difficult for new lawyers to learn, and it was for me. I didn't take a trial advocacy class, so I didn't have somebody to help me with this. Now, that's one of the reasons why, when I get ready to try a case and I knew that I had to do direct examinations of my clients, I would write out all of the questions. Now, a lot of lawyers don't do that. They know the facts of the case, so they just get up there and extemporize. But I'm kind of a perfectionist, so I would write out all the questions and I'd call the witness in to my office and I'd sit down with them and I'd say, okay, these are the questions I'm going to ask you. And I'd ask the questions and I'd get their answers. And a lot of times people would forget, for example, certain facts. And, maybe they forgot that they said that it was raining initially and before the accident. So, they'd answer the question and they'd leave out the part about the raining. And I would change my question. I would say, okay, what can I ask you that would clue you in to what, what the weather was? And then you just ask before you get to that point, what was the weather that day? So, those are open-ended questions, and that makes a perfectly understandable exam. The key thing about doing an exam is that you're telling a story. So you want the story to come out of your witness's mouth, but you have to, in essence, work them like a marionette and get them to tell you what they need to tell you. Several years ago, I worked with a friendly witness, somebody that I knew very, very well, and we're in a case, and this witness had told me, basically that in a situation where it was important that someone at work had done something that was unlawful, and she had said that, and I had written it down, and I'd shown her the statement, and she agreed that that's what she had said. When she got to trial, she didn't remember it, but I think it was a little different than that. I think she'd been pressured by the people in the job where she worked not to say that. So we asked the question several times. She still would not get that piece in. And as a result, we just left it alone. At the end, it didn't make a big difference, but it can make a big difference if you don't sit down and go through this. And if you sense any pushback as a lawyer, you have to make sure that they're going to come and tell the whole truth and nothing but the truth. So that is the information that somebody asked about with regard to leading questions and open-ended questions and when they're appropriate. Again, just summarizing, open-ended questions are the only way you can examine a witness on direct examination unless you have the witness declared hostile, or you can sneak one in every now and then as a follow-up, just to clarify. Usually judges will allow you to clarify something that somebody said with a leading question, but an entire question about something that happened, you're not going to get to do that on direct exam. I want to thank the person that asked me this question, and I will be back shortly, a couple of days, once we get back from Norway. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.